Are we ready, Rachel, with the
yeah, we're live.
The live. Brilliant. Okay. Fantastic. Right, well, good afternoon, everyone. Thanks very much for coming to this next panel, the Postgraduate Conference here at the University of Liverpool in Human Rights Law. So we've got 3 speakers this afternoon with some very interesting and varied titles as well. So it promises to be an excellent session. My name is Dr. Mike Gordon, and I'm going to be chairing the panel. But I think without further ado, we're obviously running a little bit behind time, around 20 minutes or so. We've got 3 papers, 20 minutes per speaker, and then time for discussion at the end. That's questions at the end after you've all spoken, so we can try and identify some common themes or challenges or whatever. And I'll obviously give you, gentlemen, an indication whenever 10, 5, 1, so Ahmed, I believe you're going to be speaking first. Excellent. And the title of your paper, Defamation of Religion in International and Islamic Laws. And Muslims who prefer the right not to be offended.
Hello everyone, my name is Ahmed, and the presentation is about defamation of religion between the West and Islam. So, defamation of religion is an issue which was repeatedly addressed by the United Nations from 1999 till 2010. Several non-binding resolutions were enacted by the UN condemning defamation of religion. The motions were mainly led by an organization called the Organization of Islamic Cooperation. This is an Islamic international organization which is made up of 57 Muslim majority countries from around the world, and it is considered as the 2nd largest intergovernmental organization in the world after the United Nations. Those resolutions were mainly, the purpose of these resolutions were to prohibit expression that would fuel discrimination, extremism, and misperception that might lead to some dangerous and unintended consequences. Some examples of the controversial issues. In 2004, a Dutch artist produced a film called Submission, which depicted Islam in a negative way. For example, depicting the Prophet Muhammad as an adulterous, homosexual, and child molester. In 2005, the Dutch newspaper called Posten published cartoons depicting the Prophet Muhammad in derogatory ways, again, such as portraying him holding a bomb. Now, for example, if we take the Danish cartoons, the reaction of Muslims was as following. Danish embassies were attacked in some Muslim countries. Another thing, some European products were boycotted by Muslims. And finally, formal diplomatic relations between Denmark and some Muslim states were threatened. Now, why were these items so offensive to Muslims? Before we tackle this question, I just want to mention 2 main points. First, the lack of respect for Islam, religion, or the Prophet Muhammad, shown by a few individuals in the West, was interpreted by many of those offended as shared by the whole EU people. It would be more accurate to say that such acts only represent people who have committed them instead of accusing the whole Western world. The second point is that some of the responses from the Muslim side were very aggressive and violent, to the extent that they were actually more likely to trigger a cycle of hatred rather than fixing the situation. A very simple answer to why those items or films or cartoons were offensive is that, number 1, Islam holds such a great importance in Muslims' lives. Number 2, the objects depicted are linked with a complex of religious communities, ideas, and emotions. So in order to analyze whether or not such items constitute a real offense against Muslims, we need to consider the seriousness of the offense itself. Now, the more serious the offense, the greater the need for the law to restrict it. The seriousness of offense is measured by two components. The first, intensity of the offense, and the second is the extent of the offense. Now, for the intensity of the offense, this intensity increases when it is directed against something which is important to or characteristic of the offended party. For example, a statement such as, all English people are bad, might offend some English people to some extent, but very few intensely. If we take other statements such as, all Muslim English people are bad, or all Black English people are bad, such statements would offend fewer individuals, but much more intensely. Why? Because the personal or the poignant character of the offense intensifies it in the individual's mind. As for the extent of the offense, the extent of the offense is measured by determining an individual's abnormal susceptibility to the offense. The more the subject of the offense is, considered to be worthy of love, respect, and loyalty, the more likely the individual is to be seriously offended by derogation of that subject. So, for example, if you insult someone's mother, a third party who doesn't know that mother will not be offended anyway near the same degree of the person whose mother has been insulted. Why? Because the third party doesn't know the mother at all. However, this analysis might be abused in the sense that some individuals might be offended by generally good things. For example, I might say, I feel offended by merely seeing women walking in public places, or I might just say, I feel offended because I just see someone who is not from my nationality. In such cases, can we account for such offenses? In such cases, I don't think so, because the law cannot interfere in such cases simply because such offenses are subjective rather than objective. And therefore, I think there is a need for another measurement to see or to kind of determine the seriousness of the offense. And that is the historical disadvantage of individuals or a group of individuals. And in order to explain this, we need to see Black people and Jewish people. Now, for Black people have suffered, like throughout the history, Black people have suffered from slavery, poor working conditions, and ongoing hatred and discrimination. On the other hand, Jewish people have been subjected to a long history of religious persecution, most readily exemplified by the Holocaust. So the rule is, individuals or groups of individuals who have experienced historical disadvantages are more likely to be offended as a response to any insult directing against them. Now, the right to free speech has a personal and moral value in the West. However, I just have got two questions. First, if the West celebrates the rights of individuals to seek truth according to their own beliefs, then what happens if someone has already, or if someone claims that he or she has already found the truth? According to Western public order, an individual's decision about how to live his or her life deserves respect. Why? Because individuals are rational beings with dignity, and so their decisions on how to live their lives should be upheld. If this is so, then why can't the same protection be extended to Muslims who happen to just find their truth in the Word of God? The second thing, an expression of opinion can be offensive in two ways. First, offense at the opinion itself. For example, a devout Muslim who might be offended by a mere assertion of atheism. The second way of being offended is offense at the manner in which the opinion is expressed, such as as we have seen, the depiction of the Prophet as a terrorist. So I think what causes the problem is the second way, not the first way. And in this context, I just say, like some people who might say, if we prohibit any offenses against religions in general, that might suppress genuine or peaceful discussions about and within religions. And I just don't think so, for two reasons. First, in 2009, the coordinator of the OIC, Organization of Islamic Cooperation, the one which I have talked about in the beginning, the coordinator of this organization, Zamir Akram, admitted that, and I quote, as long as discussions are held within an atmosphere of respect and desire to genuinely seek the truth, religious criticism is important for introspection, dialogue, and better understanding. So we should exchange ideas as long as nobody is offending the other. The second point is that a position paper from the European Center for Law and Justice spoke about drawing a line between, and I quote again, valid criticism of religion or religious practices and speech that doesn't serve any purpose except to offend the sacred beliefs of individuals or religions, end of quote. We can see now that both the West on one hand and Islamic law on the other hand agree that there is no such any right without any limitations. Indeed, introducing limitations to rights in general is meant to serve the individual and the community in which the individual lives. This is even expressed by the US Supreme Court Justice Oliver Horn's famous analogy, and I quote, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic, end of quote. Therefore, both international human rights law and Islamic law introduce many grounds to restrict free speech, right? Such as public morality, public order, public welfare, and protecting the rights of others. The problem is, who can define those grounds? The European Court of Human Rights has proposed something, and that is, they said that expressions should be restricted according to the local communities. So what local communities think that this should be restricted, it should be restricted. I actually, it's very useful to quote their quotation. And I quote here, the court said, it's not possible to discern throughout Europe, a uniform conception of the significance of religion in society. It's not possible to arrive at a comprehensive definition of what constitutes a permissible interference with the exercise of the right to freedom of expression, where such expression is directed against the religious feelings of others. A certain margin of appreciation is therefore to be left to the national authorities in assessing the existence and the extent of the necessity of the interference. So the court here, the end of court, the court here is basically saying that whatever this local society thinks something should be restricted, it must be restricted. Now, if the right to free speech cannot be unlimited, then there must be some unprotected speech. The most relevant one is hate speech in our context. Now, Article 20, the second point of Article 20 of the ICCPR, International Convention of Civil and Political Rights, says that any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. Indeed, the UN Committee of Human Rights has derived, I quote again, a right to be protected from religious hatred, end of quote. Now, although hate speech has been a ground for restricting the right to free speech, the concept of hate speech is not very clear. In 2009, a fact sheet on hate speech was issued by the Council of Europe, stating that, I quote again, the definition of expression of hate speech is sometimes difficult because this kind of speech does not necessarily manifest itself through the expression of hatred or of emotions. It can also be concealed in statements which at first glance may seem to be rational or normal, end of quote. In any event, if we take Article 20 of the ICCPR, along with the analysis included in the case of Brandenburg versus Ohio in the US Supreme Court here, when they talked about free speech, they actually said reducing illegal elements, reducing illegal actions must be restricted. So if there is something that might reduce something which is illegal, it must be restricted. So we can see now the emphasis is not on the speech, it's on the outcome of the speech rather than the speech itself. So if there is a speech which causes crime or violence, the priority here is to stop the violence and then to address and discuss why such speech is offensive. So what groups are protected from hate speech? In 1997, a recommendation letter was issued by the Council of Europe stating that hate speech includes not only expressions which incite, but also expressions which, and I quote, promote racial hatred, xenophobia, anti-Semitism, and other forms of hatred based on intolerance. Now, there are many racists, religious groups, and victims of intolerance who might benefit from laws prohibiting hate speech, such as Black people, Jews, and most interestingly, homosexuals. Now, the European Court of Human Rights upheld a domestic hate speech legislation in Sweden in a case called Vigiland versus Sweden. This legislation prohibited criticism of homosexual behaviors. Now, the court here held that speech in question, and I quote, did not directly recommend individuals to commit hateful acts. Nevertheless, it is amounting to serious and prejudicial allegations, end of quote. The most important part of this judgment is that the court actually said that we should restrict the right to freedom of expression in two ways. First, and I quote, attacks on persons committed by insulting, holding up to ridicule, or slandering specific groups of the population, and speech used in irresponsible manner, end of quote. My main argument is this: Muslims should be protected as much as Black people, Jewish people, and homosexuals are protected for two main reasons. First, the reason why these specific groups are profoundly offended is because by certain speech, is because certain speeches are directed against something they hold very precious. So, for example, Black people say or preserving their dignity is very precious. Similarly, for Jewish people, the idea of solidarity with martyred relatives for Jews is very important. And therefore, I just say, if God or Prophet Muhammad or whatsoever, if they hold the same amount of significance in Muslims' lives, then why not to protect them as well? The second thing is, another reason why we might kind of include the Muslims within the exceptions to free speech right is that terrorism has been undertaken in the name of Islam. Lay people, therefore, might just be more likely to fear or even hate millions of innocent Muslims. Indeed, there have been many aggressive and discriminatory acts targeted against Muslims whenever a terrorist attack takes place. Therefore, the more terrorist attacks are taking place in the name of Islam, the more likely people will offend Islam, and the more likely Muslims, especially who live in the West, would feel alienated and discriminated against. In conclusion, I just ask this question: does an attack on religion do for Muslims what criticizing homosexuals, denying the Holocaust do for Western people? And I actually borrow a quote from Joel Filberg, an American scholar, who says, and I quote, "A religious practice or moral conviction may be just as dear or sacred to a totally committed person as the memory of murdered kinsmen is to the Jew or the black." Thank you.
Thank you very much indeed, Ahmed. Very interesting. Donato, I believe you're next. So Donato Galtieri from the University of Italy is next. Title of your paper: Rival or Mutually Reinforcing Regimes Protecting Biological Diversity and Human Rights Against the Threats posed by Invasive Aliens. Correct. Thank you.
So, good afternoon, everybody. My name is Donato Galtieri, and I'm from Italy, from the University of Eastern Piedmont. And this afternoon, I will talk about my last research interest, that is the protection of biological diversity on the one hand, and the protection of human rights on the other hand, in cases of biological invasions. Now, what are biological invasions? Oh, I will, before start the PowerPoint. Okay. Sorry, I did not notice it. And to explain such a complex and broad topic, I thought about using a case coming from history, from a real-life scenario. And this is the introduction of Asian carp in the United States in the mid of the 70s. What happened? Basically, in Arkansas, there were a lot of fish ponds, a lot of fish farms where fish were, there were those fish farms that were full of algae that needed to be removed in order to have the water clear and useful for fishes. So what happened? To remove those algae, there were the introduction of Asian carp that had a great advantage. They could eat daily the 20% of their body weight in plankton, so they could filter the water. But there was an underestimated risk, that is, fish can escape from enclosures. So that happened. In the 80s, there were floods that brought those Asian carps to spread in the basins of the Illinois and Mississippi rivers, to the point that today, 95 to 97% of the biomass in those rivers is represented by Asian carp. So this is quite shocking. And the next great problem is if those Asian carp arrive to the Great Lake regions. In the Great Lake regions, there are interests and a fish industry that is worth $7 billion. And so the damages would not just be to the biological diversity of the lakes, but also to economic and social wealth of people. Now, that is why the government of the United States has spent $2 million just to prevent the occasion that those Asian carp can enter the Great Lakes region. But this is not working at the moment, just because a species of an individual Asian carp has been found 6 miles away from the Lake Michigan. So notwithstanding $200 billion spent in prevention, it is very likely that Asian carp will enter the basin of the Great Lakes region. Someone just suggested a far more economic solution, that is, if you can't beat them, eat them. And there are a lot of recipes in this website, and there's also good news. It seems that Asian carp have a really good taste. A blind test that has been run from the University of Minnesota has found that the Asian carp easily win over far more popular species such as catfish. So maybe there are invasive species that can be eaten, but not all invasive species are eatable. And this means we need some more useful and working solution. So jokes apart, we can see from this story some basic features on invasive alien species. So what are invasive alien species? Are living organisms that are established outside their natural range of dispersal. And we see that there is a great role for human agency in facilitating the introduction and spread of invasive alien species in host ecosystems. This means that when an invasive species enters a place that is outside its natural range of dispersal, it is precisely because humans have intentionally or unintentionally introduced these species through the movement of goods and people, so basically through trade and tourism. If those invasive species find favorable conditions, they can incept a process that is known as biological invasion. A process of biological invasions, in the words of Valery and Simberloff, happens when a species have acquire a competitive advantage following the disappearance of natural obstacles to its proliferation, and when those species become dominant in an ecosystem that was not their ecosystem. This is precisely what happened in the Mississippi and Illinois rivers because of the concurrence of two factors. On the one hand, in the North America, there were no natural predators for Asian carp. On the other hand, Asian carp female individuals are extraordinarily fertile because each female Asian carp can lay 500,000 eggs every time she spawns. So when there are those conditions and a biological invasion occur, there are considerable costs, both in terms of biodiversity loss and socioeconomic damages. As far as the biological loss is concerned, the Secretariat of the Convention on Biological Diversity has found that in the last 4 centuries, almost 40% of animals' extinction for whom we know the causes have been caused by biological invasions. In relation to the socioeconomic costs, and here is the point of my presentation, the invasive alien species exacerbate poverty and threaten development through the impact on agriculture, forestry, fisheries, and natural systems. So those are really the basis of poor people's livelihoods. So this means that invasive alien species and biological invasion can really have an impact on the enjoyment of basic human rights, such as the right to food or the right to health. And we have also seen, last but not least, that the prevention would be the most effective response, but is not always feasible, and however, it is enormously costly. So, we can now define the research problem. That is, we have seen that biological invasions have really great consequences, both in environmental and socioeconomic terms. And so there is the need for a comprehensive and synergic effective response by national and international policy and lawmakers. That is why in the last decades, we can start by the 70s with the Convention of Migratory Species, which had an ad hoc provision for invasive species. But usually and conventionally, the starting point of the regulatory effort against biological invasion is thought to be the CBD, the Convention on Biological Diversity. It has been signed in 1992. And there is also a recent regulation by the European Union on the prevention of the spread and uncontrolled diffusion of invasive species in the territories of the European Union. So there is a first array of interventions by national, regional, and universal organization against the threat posed by invasive alien species. Yet, there is this gray area that is not covered at the moment, that is the interplay between the environmental protection on the one hand and the social economic development and the respect of fundamental human rights, e.g. the right to food and the right to health. The research question is now, is it possible to enjoy at the same time ecological preservation and human rights? The two fundamental approaches that have been suggested until now are the human rights-based approach and the ecosystem-based approach. On the human rights-based approach, we have the attempt to ensure that both the standards and principles of human rights are integrated into environmental policymaking in a way to strengthen the so-called panel principles that are public participation, accountability for violations, empowerment of individuals, and guarantee the rights for all in equal and non-discriminatory way in the respect of the legality principles. As far as the ecosystem-based approach is concerned, it is based on the application of appropriate scientific methodologies focused on levels of biological organization, which encompass the essential structure, processes, functions, and interactions among organisms and the environment. In the ecosystem-based approach, humans are recognized to be an important component of the ecosystem, but still just a component. It is so difficult to accommodate both those approaches, the human rights-based approach and the ecosystem-based approach, in the framework of such a peculiar phenomenon, such as invasive alien species. And in my opinion, those two approaches have one fundamental limit, that is that they tend to polarize the debate on the extreme represented by anthropocentric and ecocentric interests. So in the human rights-based approach, environmental concerns are seen as instrumental to the achievement of human needs. On the other hand, on the ecocentric approach, the role of human agency in determining biological invasions is rather downplayed, because again, humans are just a part of a larger ensemble composed by the ecosystems. Now, furthermore, the human rights-based approach loses much of its strength in the field of biological invasion because it's not always easy to demonstrate that a state, I take the example of the right to food, it's not always easy to demonstrate that the state is not doing enough to protect the right of people to be fed, to have accessible and have adequate and undiscriminated access to food. Just because sometimes biological invasions transcend national borders and national capacities. On the other hand, I suggest as a possible solution the integration of human agency and local ecological peculiarities in a community-based management approach. What is a community-based management approach? It's a community-led process based on communities' priorities, needs, knowledge, and capacities, which should empower people to plan for and cope with the impact of biological invasion. I borrowed this expression from Hugo Reid that used this approach already in 2006 in relation to climate change. That is another topic, another issue that is a transboundary issue in itself. In this community-based approach, there would be a three-tier based on prevention, eradication, and control of biological invasions in accordance with Article 8H of the Convention of Biological Diversity, under which community members should prioritize and implement some of those activities. Increase of livelihoods resilience by promoting local seed or animal varieties. This is what is basically happening in the university where I completed my PhD in Pavia, where the botanical garden held a seed bank with local seeds that are starting to be used in order to promote those livelihoods resilience. Again, another solution is the prevention of intentional or unwanted introductions. And in this case, a good starting point would be the application of the EU regulation on invasive alien species, at least in the territory of the European Union. Again, there will be a capacity strengthening of local civil society and government institutions. That means the ecosystem-based approach had a great limit insofar that ecosystem not always coincide with the territory of a state. In this case, the prevention effort would be focused on the local level more than on the state level. So to try to get those local regimes and the ecosystem closer. And last but not least, there will be the advocacy and social mobilization to address the underlying causes of vulnerability. So my intervention was planned for 15 minutes, so I think I've been largely in time for the 20 minutes. And I thank you for your interest and for your questions, comments, and critical remarks when you want. I need your feedback. Thank you.
Thank you very much indeed. I'm sure there will be feedback to follow in the discussion section of the panel. So our third speaker in the panel today, Richard Watkins from the University of Nottingham. And the title of Richard's paper is Interpreting Article 2 of the European Convention, Guaranteeing Soldiers' Right to Life.
I don't have a PowerPoint presentation, so you can just concentrate on my beautiful face. You will have to bear with me because I am losing my voice. I was just going to play you the first 20 minutes of Saving Private Ryan, but then I thought I probably ought to say something. So in 2013, the UK Supreme Court decided in Smith and the Ministry of Defence that soldiers are within the jurisdiction of the state for the purposes of the European Convention on Human Rights, no matter where they are in the world. So the state has to fulfill its convention obligations to its soldiers, no matter where they are on foreign deployment. So if we send them out to Afghanistan, we still have to protect their fundamental rights. Well, the first substantive right in the European Convention is found in Article 2, and it provides that the right to life shall be protected by law, and that no one shall be intentionally deprived of his life. So, first of all, there's a prima facie negative obligation that you're not going to get killed by anybody. But the court has also judged, the European Court of Human Rights, this is, has judged that the right to life means more than just thou shalt not kill. States are also required to protect people against any risks to their lives, whether that's from criminal activities from third parties or from inherently dangerous activities, or even from themselves. So this positive obligation requires states to take certain actions. They're liable for their omissions if they fail to take these actions to protect people from risks. The positive obligation has been inferred as part of the requirement to protect the right to life by law. But when we think of protecting the right to life by law, we usually think of legal instruments like public health measures or criminalizing murder, that sort of thing. You don't usually think of practical operational measures to protect life as opposed to the right to life. So drawing this responsibility to take these positive operational measures from an obligation to protect the right to life by law distorts the wording of the convention. And the positive obligation in its current form doesn't really have a textual anchor for what it tries to do. The courts just sort of imagined it out of nowhere. So what I'm trying to work out is whether there is a way of interpreting Article 2 in such a way that gives the positive obligation a better textual anchor. So in the positive obligation cases, the court never uses the language of deprivation of life, which is what is prohibited in Article 2. The negative and positive obligations are are drawn on a very simplistic understanding of action and omission, even though the court's never actually examined what actions and omissions are. So why can the liability for omissions not be drawn from the prohibition on deprivation of life? So to answer that question, I'm going to be looking at the philosophy of action and omission and how that relates to the negative and positive obligations. And I'm going to suggest my new interpretation of Article 2, and then I'm going to apply that to a real situation in which a soldier was killed to demonstrate how it would work in practice. So in the court's jurisprudence, only an action can constitute a deprivation of life. What is an action? We generally think of actions as things that people do rather than things that happen to people. But doing is a really imprecise verb. It can include things like blinking or sneezing, things that you would think of as being passive behavior. So what sets passive apart from active? Thomas Aquinas wrote that action is the origin of movement. That's quite a good place to start. If we say that action is a bodily movement, but blinking and sneezing are both bodily movements as well. So what is the point that makes it different? What we need to say is that action is bodily movement that is intentional under some description. How do we describe intention? A causalist would say that we can redescribe an action in terms of its primary reason. And the primary reason is a pro-attitude, a positive inclination, a desire towards movements having a certain quality, and a belief that a given movement has that quality. So for instance, I might have a positive inclination towards movements that have the quality of lifting the cup to my lips so that I might drink, and a belief that doing it in this way will have that quality. The desire belief, according to a causalist, is what causes the movement. But the desire belief has to be the direct cause of the movement for it to be considered an action. So if I'm at a party and I'm in a particularly impish mood, I might decide that I want to annoy my host. And I might have a positive inclination towards an action that will cause my drink to spill, and that will annoy my host, and a belief that moving my hand in a particular way will do that. But what if my desire belief makes me nervous and my hands start shaking and I spill my drink that way? There's a primary causal deviance. The desire belief itself is not what causes the movement, it's my nerves that do it. So is that an action? No. As long as you have proximity between the desire belief itself and the action, and the movement, we can call it an action. So aside from the causal deviance problem, there is the fact that a causalist perception of intention encompasses a lot more than just the movement itself. So my desire belief is to annoy my host, broadly. But whether my host is actually annoyed by me spilling my drink is not something I can control. The causalist model takes a fairly broad, coarse-grained view of action individuation, in the sense that it includes these elements that are beyond the scope of the movement itself. The non-causalist definition takes a far more fine-grained approach to action individuation and only looks at the movement itself. So the non-causalist model defines action as a movement that is purposive. It's guided by a mechanism that compensates for the effects of external forces. And the guidance has to be done by the agent themselves. So the movement is completely within the agent's control. So these movements are things that are not nomically necessitated. And we say that something is nomically necessitated when it occurs as a result of the application of the laws of nature to an antecedent state of affairs. When I deliberately pour my drink on the carpet, I'm in control of my movements, I'm acting. But when someone bumps into me, for instance, and my drink goes flying out my hand, the spillage occurs as a result of the laws of gravity acting on the glass, and not as a result of my control. So action is bodily movement that's intentional under some description. Both the causalist and non-causalist models are valid philosophical definitions. Choose whichever one you prefer. The problem is that under either of these definitions of intention, omissions can be intentional too. So if you suppose that you're standing in the park and there's a baby face down in the puddle in front of you. You don't do anything, you just stand there watching, and the baby drowns. Your standing still can be redescribed in terms of a pertinent desire belief. You have a positive inclination towards movements that have the quality of letting the baby drown, and a belief that just standing there doing nothing has that quality. Similarly, the whole time you're standing still, you're in control of your body. If you're not, you'd be lying in a crumpled heap on the floor. But what is an omission? We describe omissions in a very sort of commonplace kind of way as a negative formulation of a positive value. We say that you didn't roll the baby onto his back, you didn't save him, it was a not saving. But by describing omissions in terms of what's missing, we can see that they are actually nothing. The way we describe an omission is really a proposition about something that could have been, but wasn't. There could have been a baby saving, but there wasn't. In a world made up of positive values, an omission is not a thing. It's not a negative act, it's just nothing. And as Rodgers and Hammerstein immortalized in song, nothing comes from nothing. I'm not going to sing for you. But though the omission can be described as intentional, in the same way as a bodily movement can, there's still something that sets the two apart, and that's causation. So deprivation of life, which is what's prohibited in Article 2, implies some sort of causational requirement. All of us have to die one day, none of us can live forever, but our deaths occur usually as a result of the laws of nature. But a deprivation of life in the sense encompassed by Article 2 of the European Convention is a killing caused by someone else, rather than by nature alone. We can describe the failure to save the baby as intentional, in the same way as we describe our bodily movements as intentional. But does the failure to save the baby cause the baby's death? Simply put, causation is a relationship between two objects or events or properties. The relationship is one of necessity. And Hume gave us the proposition that the second object relies upon the first, giving a but-for test of causation. If the proposition that but for A, B could not have happened is true, then A is the cause of B. A deprivation of life, then, is death that would not have happened but for someone's action. But why not omission as well? In common parlance, we might well say that the baby died because you didn't save him. But is this failure to act, is the omission truly causative of the baby's death? But for the omission to save him, he would not have died. But you do nothing. It's the same as if you weren't there at all. So it's really an overdetermination to call the failure to save a cause. Ignoring for a second how the baby came to be there, once it's face down in the puddle, the conditions existing are sufficient for death to occur without needing to look at what else might have caused it. And from a policy perspective, if we call the failure to save causative of someone's death, then anything might constitute deprivation of life. I didn't save someone being run over by a bus down the road. Did I kill them? No, of course not. So it's open to infinite regress and is impossibly broad. And when we're trying to set a set of workable and effective protections for the right to life, that's not what we want. So when there's no action, there's no metaphysical relationship between the agent and the death he failed to cause, or failed to prevent, sorry. So the court has seen fit to impose liability for omissions on the grounds that it constitutes a failure to protect the right to life by law. Where there's an action that causes death, it will constitute a prima facie violation of the negative obligation not to kill. But this cut and dry approach isn't always possible. An omission to save will often follow an action. Since the omission itself is not causative of the death, we might say that the action that's prior in the chain of events has caused it. In which case, is there a deprivation of life? In the cases in which the court has developed the positive obligation, someone is usually died as a result of someone else's action. In Osman, for instance, which is the seminal case on the positive obligation, the applicant's husband was killed as a result of someone else's criminal act. There was an intentional deprivation of life. It wasn't caused by state agents, but their inaction allowed it to happen. Although, in that case, obviously there was no violation. But the court's correct in its practice, therefore, that only actions can constitute deprivations of life. And the philosophy of action and omission supports that approach. But the court's erred in its interpretation of Article 2 by limiting the application of that prohibition on deprivation of life to state agents only. Article 2.1 says that no one shall be intentionally deprived of his life. And although the convention is addressed to states and binds states, the content of Article 2 doesn't mention state agents at all. The wording of the article creates an expectation that people won't be intentionally killed. This prohibition obliges the state to prevent deprivation of life by restricting the situations in which its own agents use lethal force, and also by taking the operational measures to prevent deprivation of life caused by others. When the state fails to prevent someone from being murdered, for instance, it's not caused the deprivation of life itself, but it has permitted another to cause that deprivation of life. Rather than failing in its obligation to protect the right to life by law, it's failed to prevent an intentional deprivation of life. So how might this new interpretation work in practice? We look at a fairly well-publicized case. There was another one quite recently in which the soldiers died, as an example. In 2010, Marine B was taking part in an SAS training selection exercise, and this involved a 40-mile hike over rough ground in the Brecon Beacons. He had to do this in 20 hours, carrying a 55-pound pack and a rifle, with no resupply of water or any other provisions. This exercise took place on the hottest day of the year, and he died as a result of complications resulting from a dangerous increase in core body temperature. Under the court's current practice, that might be a risk against which the state should have taken some precautionary measures under the aegis of protecting the right to life by law. But if such a case ever came to the European Court of Human Rights, I don't think they would hesitate to say it was a positive obligation case, and that's probably right. But since the positive obligation in its current guise has no proper textual anchor, it's difficult to say with certainty. Whether a case falls under the positive or negative head of Article 2 seems to depend upon the court's discretion and whether the court perceives the facts to include an action or an omission. But in the cases of failure to save, as I've said, there's often an act that precedes the omission. By bringing the positive obligation within the textual anchor of the negative, as I've suggested that we do, we move away from the court's discretion and provide the positive obligation with a proper basis in the text that can be examined and scrutinized effectively. Under my new interpretation, there must be a deprivation of life that the state's inaction failed to prevent. So for Marine B, was there a deprivation of life? A deprivation of life is death that results from an action. In taking part in the exercise, Marine B was following orders. So when his superior officer, O, gave him the order to participate in the exercise, he acted. He moved his body in such a way that can be considered intentional. On a simple counterfactual test, Marine B would not have died had that order not been given. We might say that his death relied too heavily upon other factors. So it relied upon him following the officer's orders, upon the weather being hostile, upon him deciding to carry on despite feeling unwell. Order giving by itself is not sufficient to cause death. It's an insufficient but not redundant part of an unnecessary but sufficient condition to cause death. There's an undeniable but not inexorable link between the order and Marine B's death. Because there are a number of other factors upon which we have to rely for Marine B to actually die, we might argue that that reliance breaks the causal chain, but we might adduce that argument for any action. Suppose that Officer O had shot Marine B instead. If he'd done that, we wouldn't hesitate for a second to say that his action had killed him. But the action of trigger squeezing, for it to cause his death, relies upon there being a bullet in the chamber, upon the gun actually firing, upon compensating for the effects of wind and gravity on the trajectory of the bullet, and it actually hitting Marine B in a way capable of causing death. But despite the reliance on so many factors, we've got no difficulty in saying that pulling the trigger caused its death. The dependence upon external factors alone cannot break the causal chain. We might say that there's so much of a time delay between the order giving and the actual death that that breaks the causal chain. But suppose that Officer O administers a slow-acting poison instead, and it takes Marine B a week to die. In that case, we'd still say that poisoning is the cause of death. So the time delay can't break the causal chain either. There's no legitimate metaphysical basis for claiming that the order giving did not cause the death. As such, there has been a deprivation of life. It will only constitute a violation of Article 2 if that deprivation of life is inflicted intentionally. According to the court's very broad interpretation of intention, that includes consequences that are foreseen and risked anyway. And I think we can say that Marine B's death was foreseen and risked anyway, so it was intentional. In the case, what actually happened, and the hypotheticals that I've mentioned instead, the death might have been prevented by appropriate and timely provision of medical care. But the failure to do so, the omission to provide medical assistance in time, is not an action, and it's not capable of breaking the causal chain between the action and the death. So the proposition that the soldier not dying, if we had provided medical care, is a postulation about what could have happened and not what did. The failure to provide medical care didn't cause the death. By failing to save Marine B, either by cancelling the exercise or providing him with medical care in time, the state didn't fail to protect the right to life by law, rather it failed to prevent the deprivation of life, which is explicitly prohibited in Article 2. The requirement to take positive operational measures to protect individuals from threats to their life, which the court has inferred from the obligation to protect the right to life by law, should be seen more as a manifestation of the obligation to prevent intentional deprivation of life. Where state authorities fail to prevent people being killed by another person, they've allowed an intentional deprivation of life. So consider now a soldier in battle. When he's shot at by the enemy, he is intentionally killed. The state has an obligation to prevent the intentional deprivation of life. There are numerous methods by which it can do that, by providing him with better armor or making sure he's sufficiently well equipped and well trained to defend himself against that attack. But it's a stretch to define those things as legal instruments. Deriving the obligation to protect people from being killed from the responsibility to protect the right to life by law makes very little sense when preventing death requires practical measures, and it's the right to life, not life itself, that the law must protect. So ultimately, there might not be very much difference in practical outcomes between what I've suggested as a new interpretation and the court's current approach, but it would constitute a systemic reform to the way in which the right to life is conceived of and applied. Perhaps it's more a linguistic than a practical problem. Whether we say Marine B's right to life was violated because we didn't protect his right to life by law, or whether because we didn't prevent an intentional deprivation of his life, doesn't really make much difference to him. All that he cares about is whether his human rights challenge succeeds. But choice of words is really important. It's vital, not only that the law handed down in the court's judgments is clear and just and fair, but also that the language that they use is coherent and intelligible. By interpreting the prohibition on deprivation of life as creating an expectation that people shall not be killed by anyone rather than just by state agents, Article 2 automatically includes a positive obligation to prevent killing rather than a mere restraint on state agent action, which is what the court's current practice seems to suggest. Thank you.
Thanks very much indeed, Richard. Right, that was fantastic. 3 great papers covering a whole array of even human rights law, it will be difficult to even capture this running. But I mean, I think perhaps as well as seeing some of the different rights there, obviously we're moving from, well, sort of in reverse. We've started with sort of core rights, ended with core rights to life, moved back through socioeconomic rights, and of course then cultural religious rights effectively. So we've covered a range of terrain. But also I think what was interesting in terms of the contrasting behaviours was that you were all identifying challenges with human rights law or frameworks to some extent, but all different challenges as well. Perhaps normative challenges that we began with, socioeconomic, environmental challenges really in instrumentalising human rights law in our second paper in Balto. And then finally the traditional kind of legalistic interpretive challenges as well that human rights law obviously poses to us. So some really interesting contrast there. But I'll throw the floor open then to questions for our speakers on any of the papers. Craig, and then we'll.
Yeah, I agree with what you said, Mike. I've actually got loads of questions, but I'll limit myself to one. I guess it's for Richard. You said that your account of causation sort of supported philosophically so that emissions aren't causal.
Yeah.
Yeah. But so there's quite sort of I don't think that's sort of a unanimous view in the literature. So Peter Singer or John Harris, for example, would say that we might actually have those obligations to say go out and save people's lives in Africa and things, and by not doing that, we're still causing them harm. So the philosophical literature on this isn't unanimous. And also, I was just wondering how you'd compare this with how, say, tort law deals with causation, because I feel like the literature on there could help you. So generally, you're not liable for, there's no duty of care to avoid causing physical injury by your emissions, but there are exceptions to that. And when there are exceptions, the causal inquiry can still take place. So you look at sort of the long run of what's happening. You can use the sort of counterfactual but-for test to still say that that emission contributed or caused the damage. So why can't we do that with the rights law?
Oh, first of all, excuse me. No, it's not unanimous. There are a lot of people who say that emissions can be causative. I don't agree with them because I don't see an emission as a thing. We describe it as a thing because our language has no other way of explaining it. But it's like the failing to save the baby instance. There was nothing there. So I don't think you can say with any metaphysical truth anyway that failing to save whatever caused it, because there was something else that was going to cause it anyway. You could have prevented it, but being able to prevent something is not the same as causing it, because the conditions are already there for it to happen anyway.
But if you accept that, say for example, if you had two hunters in wood, you go, to use sort of a trite example, you go 5 bullets on the same person, each of those, there's a sufficient causal situation there. So would you say both hunters aren't liable because hunter A, him firing the gun, is sufficient, so hunter B is not made any difference? Could not the same apply with emissions? There's already the sufficient circumstances for the injury.
But in that case, if you've got the two hunters, if you could prove which one the bullet came from, then you would prosecute that person. But if you can't prove it, then you prosecute both of them and see what the jury said.
But you can't prove on balance of probabilities which ones. In tort as well, depending on balance of probabilities. And also, I think like in law as well, does it matter that much, like what science and philosophy says about causation? Because whereas me, say, pouring petrol on somebody and setting fire to them, a scientist, the oxygen in the air is just as much a cause as my actions, but for law, in tort, you're looking at whether the breach of the duty of care has caused the damage. So in human rights, should be looking at whether the wrongdoer has.
Yes, I agree. The whole of law doesn't all make sense when you apply that sort of theory. I think there is a place for philosophy. I have to say that because my thesis has a lot of it. But I mean, there isn't a unified approach to anything. There isn't a one-size-fits-all for any aspect of law. This is just my take on how it works for this particular part of it. Admittedly, it's just an idea. It might be wrong. If everybody agreed with me, then there'd be no need for me to write a book, because everybody would think the same.
I mean, definitely, I definitely think what you're saying is worthwhile, but I was just wondering whether you might overstate your case, because otherwise this would have implications for like the whole of talk.
There are interesting parallels with tort law, which I have explored a little bit, not over much, I admit, but which are sort of the next thing on my list, if you like, to look at. So thank you.
Okay, let's move on from tort lawyers coming in and causing problems in the human rights panel. Thank you, Craig. Gentleman in front.
One question for Ahmed. Well, you mentioned the case law of the European Court of Human Rights. In my opinion, in that case, the problem is that approach is not working because the factors say, well, it's the local communities, so basically the member states, which establish which is morality and which is the limit. As if you consider the thing at the European level, that's more to discriminatory results, because on the one side you have cases in which you say, well, it's absolutely fine that the authorities permit you to project a blasphemy movie against the Catholic religion, but on the other side, because they allowed the Swiss authorities to stop a teacher wearing hijab without anyone complaining about it. Now, and I was explaining this approach to an audience of non-lawyers, which was simply really upset, because they said, well, actually we pay 10 people or whatever in Strasbourg to decide, and they basically have found an approach according to which they don't decide, because the problem is not that there are limits to the freedom of speech. We know that there are limits to the freedom of speech, but is where do we draw the line? And then also in relation to the relationship with Islam, is also problems that nowadays that the offense, well, if the offense takes place in the European territory, we can use the principle of territoriality, saying, well, it is the European concept of morality that matters. But the problem is that sometimes, as in the case of Charlie Hebdo or in other cases, it is a piece of art, maybe, that is produced in Europe, but which is read or seen in an Arabic country by Muslim people who are not moving to Europe, but they are in their country. So where does the violation take place? Which kind of morality we apply? So
yeah, thank you very much. As for the first part, I totally agree with you. Just leaving everything to the local authorities might be a little bit confusing. But the thing is, personally, I just think that's the only way to do it. Because if you think about the idea of universal human rights, I think it's not going to happen as well. Because if you take not just free speech, right, let's take something else. Right to life. Execution takes place in the US, but not in the EU, for example. The right to freedom of religion. Covering up your whole face as a woman in France is illegal, but it's legal here. So there is a variety of interpretations when it comes to what does a right to something mean. And this is, of course, due to the fact that public morality is different from one place to another, public order, public welfare, and so forth. So I think this is the only way to deal with it. You can't really have a universal, like, you can't really say the right to life means there is no execution and just implement it in everywhere, because this is not going to happen. Like, practically talking, this is not going to happen.
Yeah, but so why we spend money and time to affirm a universal human rights? If we don't apply them to the singular and we don't
that's a good question. I'm actually asking this sort of thing as you do. I think, practically speaking, this is not going to happen. And if you take this argument into a philosophical one, I think you, like, for example, my thesis, my first chapter is about discussing the idea of international human rights. I'm just saying, people in the West, the priority for people in the West is the individual, while in Muslim states, then the priority is God, let's say religion in general. Now, how, if you get one person from the West and one person from the Muslim countries, how can you convince, let's say I'm a guy from the Western country, I say, how can you convince a Muslim individual who has been raised up his life with one thing, the law of God is, or have the priority among others? How can you convince him that the individual is more important than God? The vice versa. How can you convince a Western lay person that God should be respected more than individual? It might happen, but it's very rare to happen, especially if you talk about like free speech in our context. When you talk about Muslims, of course not all of them, but I would say a huge number of Muslims would actually say, kill me, but no, don't mock my God. And this is very important. Instead of trying to kind of fix this situation by trying to impose the idea that the individual is more important than God, or God is more important than the individual, we need to just treat the problem as it is, because I think there is no way out of it. As you mentioned, Charlie Hebdo, of course, nothing can justify killing innocent people. But like, think about some of the brands after the attack. The one which is, I am Charlie Hebdo. Now, I have asked many of my friends who live in France, and they were under pressure because, on one hand, they of course condemned the attacks, but on the other hand, they couldn't really say that mocking the prophet was okay. So the French people would actually say, if you don't kind of support us, it means that you are supporting terrorism. And this is kind of dangerous because I think you're putting the people under pressure. The thing is, some Western people just picture every single Muslim as a group. So if we are 3 Muslims, I kill someone, it means the 2 of them are with me. I think this should be addressed in a sense that we need to look at Muslims or Jewish or any race or religious groups as individuals. So don't, as I have said, even in the West, if someone mocks God or religions or whatsoever, it doesn't mean the whole West is with this person. It only means that this is an individual act.
We're pushing our time. I think if your colleague would like to come in, just with a quick point.
Thank you very much. Sorry, Ahmed, I didn't attend your full presentation. I think from your presentation, it boils down to 2 issues. First, who is conferring the right? Are you talking about lawgivers, legislatures, or judges who are interpreting defamation law to include any kind of, to apply these kind of religious symbols as being, a subject of offense? Second, that's the first question. Second question is, what religious symbols are we talking about? Are we talking about the practice of people, their way of life, a religious, historical experience that they hold dear? Or are we talking about God or prophet or prophets or gods who are shared by many religions? And I think that there's a gray area that we don't know religious symbols should be protected, and those people who are believing in these symbols. So I don't know. I mean, how first who is comparing the right? We said, oh, second, who are we protecting? The individual who's living in this age and time and living in this society who can benefit from human rights, defamation law, all of these laws, are we protecting what he would act on as saying, yeah, this is my right. My right is as the right of my prophet or my God or whatever that is.
Yeah, well,
yeah, that's fine.
Yeah, sure. Well, one of the issues about defamation of religion laws is, and that's why some of them were rejected in the UN, because they didn't really know what to protect. So if someone insults a religion as a whole, that would be a defamation of religion. But what if you insulted a character which is really important in the religion? So, for example, if you insulted someone who was with the Prophet Muhammad in the Islamic history, that might be prohibited as well, according to the Islamic law. And that's why this is one of the things, or one of the issues to tackle when it comes to kind of legislating defamation of law resolutions. If you look at the local authorities, if you go to a Muslim country, they will definitely have some kind of an idea of what to offend and what not to offend when it comes to religions. Why and how? It depends on the local authority and the local society as well. But interestingly enough, if you even look at the European Court of Human Rights, there is a case called Otto Preminger versus Austria, and there was a town. I don't really remember the name of the town, but it's in Austria, and the majority of its population is Roman Catholics. And there was a movie, and this movie was prohibited. And I quote here the court's decision. The court prohibited a film to protect the right of citizens not to be insulted in their religious feelings. Now, I think the answer to your question is it depends on the local community. Now, in this case, the court analyzed the issue and the movie, and they actually watched the movie, and they concluded that this movie, if this is displayed, then people will be outraged, and so it should be prohibited.
There was a question here as well. Was there one at the back also? Let's take a few questions then, and we can just have final responses from the panel. Do you also want to come in?
Two quick questions to Ahmed. So I'm more of a theory guy. So basically, you are rejecting the liberal legal theory and the superiority of democratic liberal understanding, which is normal. There's a whole sets of books which criticize that. But I'm speaking in the European framework, and I'm asking that how can we find the balance between hate speech and freedom of speech? Because I think it's more than what's the substance. It's more than what's the substance. It's about how do you say something, what's the meaning to say. So for instance, drawing the prophet as a child molester or Satan is obviously hate speech because there is no point to do that. But let's say I argue that the high rate of child and teenage brides in Islamic population derives from the fact that prophet married with an 8 years old girl. And I argue that in an article, let's say. So most probably it's going to be offensive for most of the Muslim people, even if I do it in a more scientific way or kind of an opinion way rather than a comic way. So it's hard to find, I guess, that kind of a balance in the European framework because, as you say, Europe puts individual ahead. And the second question in conjunction with this, you talked about the truth and finding the truth. And let's say a Muslim in Europe found the truth and he wants to live his life in a way. But the thing is, truths might be conflict in an incompatible way. And because religion takes some stuff as given, rather than analytically discuss that, it might be unresolvable problem for us. So, and since the European human rights understanding is one way, so it means it's impossible for a Muslim to find the truth that is contradict with the understanding in a European way, living Europe. So that's how I conclude from what you say. So it's pretty much what I'm going to ask. Okay, so once again, thanks for your presentation.
Before you respond, thank you very much. just get another couple of questions, comments, and we'll have fun. At the back, please.
I was going to say something quite similar to that, which is that if you're going to make this distinction between what's causing the offence being either the opinion being expressed or the manner in which it is expressed, or potentially the reason for which it's expressed, I think you need to make some room there for the value that provocation can have in terms of freedom of expression as well. So it's not necessarily that all provocative statements will be ones that you could restrict, I think, personally. But the question I was actually going to ask was, there seemed to be, through all the cases you went over, two broad reasons for protecting people against.
Okay, we're on the verge of concluding in about 15 minutes or so.
I'll be really quick.
Yeah.
So you've got two reasons to protect people against insults against their religion. They might be a sort of dignitarian, individualistic way of looking at it. So each individual within this group is offended. But most of them, so the US, the UN, the ICCPR, seem to focus on the consequences of the expression, so public disorder, hatred, and misinformation, all that sort of stuff. And these, the European Court of Human Rights seems to be the only one that is protected people against offence. And I just wonder which of those do you think is really the best way to do it, because I'm not sure that if you grant people a remedy for being offended, then that's not susceptible to disproof.
The impossible task of responding to those questions in approximately 30 seconds. Go. Don't waste time thinking, just speak.
As for your first thing, religion, that religion can't be proven. Like the truth about religion might not be proven. Well, if you consider the evidence provided by people who believe in God and so forth, you might not be convinced. But I think that one of the things to consider here is, what about the Western view as well? Is it practically proven? As I said in my presentation, if you go to a religious person and just say the individual should be protected in all times, how can you make this claim practically proven? I don't think so.
Of course, but Islamic will accept that. Muslims accept their understanding as unchallengeable, while Western world or scientific accepts it's challengeable because they can accept the challenge. That's what I'm
correct. So that's why what I'm proposing is that if both parties don't want to accept the other one's opinion, and if both of them think that his or her opinion is correct, then leave it as it is. I think this is the best way, because if you don't do that, there will be a lot of conflict between them. So don't kind of enforce your views on the religious party, and on the other hand, the religious party should not impose or enforce his or her views on the liberal or, let's say, agnostic or atheist party whatsoever.
And the question in the back?
Yeah, question back. As far as I have understood from your question, you're saying that I think that there is kind of a difference in approaching the right to free speech between the EU law and the American law. That's correct. I think the US law is more concerned about the consequences of the free speech, while in the EU it's more about values or whatsoever. I think you're correct, and the evidence to that is the Holocaust denial, for example, is prohibited in Germany. So if you stand up and just say the Holocaust didn't happen in a public place, you will be prosecuted. Why this doesn't happen in the US? I would say I would go for a combination between both of them, because at the end, if I know that German people, the German population would be seriously offended if I just deny the Holocaust, I shouldn't do that, especially if I'm there in their territory. So I would really be more concerned about the consequences, because I think this is what the purpose of any law. I mean, like one of the attempts on Muslim scholars to persuade the West to kind of prohibit offenses against religion is to associate it with the individual, because they already know that the West is focused on the individual. So they say, look, we need to protect religion, not because we need to protect God. God indeed doesn't need protection, but because we need the protection of the individual. Because if you go to a Muslim state, I'll just say, you just insult God, you will definitely make or cause some kind of violence there. And I think the ultimate aim is to protect the individual. I think the consequences, considering the consequences, might be a better solution.
Wonderful. A lovely note to end on. Donato, I wanted to ask you about polarisation of human rights, but we will have to pick that up later, I'm afraid. So I will come and catch you later for that. But thank you very much indeed to you in the audience for some wonderful questions and discussion. And thank you most importantly to right. Thank you very much, everyone. The soapbox is on. Where is it on? Let's do this.
That's a problem with that.
Something like originating or soldier just continue.
Oh, yes.
Going into
Yeah. Does it think it's related?
yeah, I do.
Because you might think, like, I'm a soldier, I decided to scroll.
Thank you.
Well, thank you very much.
Thank you very much, Judge Paper.
So, like, would you consider this, would you say that this is kind of a violation against someone's rights?
I will catch you about that polarization.